Right, we're live.
This is Senate Appropriations, and we're now taking up H217, which is right now a miscellaneous amendment to the workers' comp program. However, we are using this bill as an opportunity to amend and to attach what was the Senate passed version of childcare. Well, not quite, but with a few of the policy changes that had to be made because of either timing or what DCF could accommodate. So we're not sure of the status of the bill and the other body, and obviously childcare has been a top priority for this body right from the get-go, and we have felt that the appropriate revenue stream to support what is a very ambitious childcare agenda would be the payroll tax. That was after deliberation in the committee next door, and our view is that it's the nexus there is very strong because that's a benefit of childcare that you get by working, and it keeps people at work and in the workforce, and therefore the nexus to that revenue source seems to be very strong. So we are going back to what we passed earlier with some modifications. They're not significant, simply because of some issues that have been identified since we passed the bill. So Katie McNeil is here to go through what we have in front of us, and Damian Lennon is here because the last 4 pages are the H217 before it was amended.
Last 30 pages.
You have 30 pages? Oh, I thought it was 4. Somebody said you only had 4.
No, because you have the contribution piece, correct?
Yeah, there's 4 pages in the childcare.
I was thinking we really, okay. All right. So, Katie, if you want to go through on the childcare in terms of what modifications we've made since we passed this bill.
Sure.
And then we'll go to the workers' comp section and have Damian present that to us.
Okay, very good. Katie McNeil, Office of Legislative Counsel. And I just want to say we also have Abby Shepherd here who drafted the revenue pieces. So we'll probably do a little bit of musical chairs.
Yeah, we have a lot of staff support as I look around the room. So thank you all for the work to get this document ready for us right now.
Okay.
And I'm sure that if you're here from DOL, you're wondering what happened to your bill. It's all related to workforce. So,
okay. So I'll give you sort of a high level overview. I know you don't want to be in the weeds. So much of the childcare language is taken from what House Ways and Means was last working on, which, included a lot of what the Senate had passed. So I'll try to highlight the differences and changes that were made to this version. We have a legislative intent section that I'm going to move over for the time being. Section 2 is the Pre-K Education Implementation Committee and Plan. You also had a Pre-K Education Implementation Committee. It was more of a study committee answering questions. This has changed, and it's a plan for how do we move forward for a public-based system that can contract with private providers by July 1 of 2026. And then some of your question topics were kind of boiled down, and they're still represented in this draft. Page 7, Section 2A is the pre-kindergarten education model contract. This is asking AOE in consultation with the implementation committee to develop a model contract for school districts to use when contracting with private providers for pre-K, and what would be in those contracts. And Section 2.
Katie, sorry. My memory was we already did that some time ago.
model contract?
That we or maybe it was an initiative within AOE. But I know that even when Rebecca Holcomb was secretary, there was work on a model contract. I sort of assumed they had moved to one
I don't know,
standard form. Is that not the case?
don't have an answer for you on that, but I think we're going to be joined by Beth at St. James
Okay, I'll say that.
shortly, who drafted some of this pre-K and education language, and I'm sure she'll have a better handle on that.
Okay,
There's also in section 2B, the pre-kindergarten pupil weight report. We have language on page 8 to see data collection and sharing. This is data that JFO needs to do their work with regard to weighting and pre-K. Section 3 changes the weight for pre-kindergarten from, so you're on page 10, line 18. This changes it from -0.54 to 1, the same as kindergarten. It's subject to take effect July 1, 2026. However, it's subject to a contingency. On the top of page 11, section 3A, there's a contingent effective date saying that the weight wouldn't be changed unless the
We
general
enact legislation.
Yeah. And then there's a list of what has to be in that legislation.
And I would just remind the, or the committee the fact that Senator Lyons has been very much involved in this language and what it includes. So even though it's taking sort of the last iteration that might be coming out of Ways and Means and modifying it some, a lot of all the rest of this has been a result of the work done by our Health and Welfare Chair.
Madam Chair, I do have a concern about this. The Education Committee has not been read in on this, I believe. And it would typically be their bailiwick. So if I could suggest that we flag this section, that specifically the section 3, which would actually change the weights, understanding that it's contingent. But section 3 and section 3A, I'd like to flag.
Okay, keep going. Section 4, this was in the Senate version. There's a concept in the Act 45 reports. You asked for a report on childcare governance and systems, and one of the recommendations was to elevate childcare within state government. And so there are two sort of companion sections in the bill. One focuses on leadership within AOE and how leadership could be restructured to elevate the focus on early education. That's what this section is. Later in the bill, there's sort of a similar section that looks at DCF and reorganization within AHS. That brings us to page 12, and we have a series of tiered or rolling effective dates for childcare and childcare subsidies. So the next 4 sections amend 3512. So we're amending the same section 4 times with different effective dates. So first, in section 5, we have language that says that there's nothing in this section that would stop a childcare provider from establishing tuition rates that are lower than the reimbursement provided under CCFAP. That takes effect January 1 of 24. And then we have language in 5A. This language was in the Senate passed version, or a close relation of this language was in the Senate version. And this is saying that the commissioner can adjust the subsidy and family contribution by rule to account for the increasing childcare costs not to exceed 1.5 times the most recent annual increase in the NAICS index. And then you have right now, families that have no copay in CCFAP, they're families at or below 150 FPL. This moves it up to 175. And similarly, you're making a change at the top of page 14. Right now, families that can participate in CCFAP, that doesn't mean they get a full benefit, but they can participate up to 350% of FPL, and this moves it up to 400% FPL. This takes effect April 1 of 24, and this is the first of 2 jumps in the family, expanding the families that are served.
And the government had proposed moving to 400 as well.
And then we have section 5B. This is language about ensuring that the applications for CCFAP are plain language, simple to use. A variation of this was in the Senate version. Similarly, there's language that individual and non-citizenship status, for citizenship status that would not necessarily qualify for CCFAP can participate using state-only dollars. A variation of this was also in the Senate version. And in your version, it took effect on July 1, 24, and it does here as well. Then we amend this section a fourth time on the bottom of page 15, top of page 16. And this is the second expansion, the second family expansion. So as of October 1 of 2024, you have already made the change on line 11 that families at or below 175 FPL will have no copay. So that appears as if it's an existing law, because at that point it will be. And then at that time, you'll make the jump from 400% FPL to 575 FPL.
So what's it? What's the-
That's October 1st, 2024. And then that brings us to the top of page 17. This has to do with the benefit or the copay that the families are contributing. So right now, families who are at 151% of FPL are paying $25 a week. And because you're jumping from 150 FPL to 175 FPL, we're sort of jumping ahead in the scale. We're jumping up to families who are paying 176. And so they're paying sort of 2 increments, which is $25 times 2. So their benefit is $50 a week. That's how we
Their
get
family
that.
share.
The family share, thank you.
And that's the same as it is right now. So that's
It
the
is.
same.
But yes, we're just saying that we don't have a share below 175.
Does that take effect?
This takes effect
July?
April 1, 24. Let me confirm that.
When the 175 takes place.
Yeah, that would make sense, which was April 1st. Yes, April 1st, good. Next, in section 6, this language is very similar to what left the Senate. This is the provider rate adjustment, sort of resetting the base of what providers are reimbursed. So we have some intent language that had been added. And then in section B1, we're saying that on January 1st of this coming year, DCF is to provide an adjustment to the base child care provider reimbursement rates in CCFAP for services provided in center-based family child care homes, after school, and summer care. And then the adjusted reimbursement rate shall account for the age of the children served and be 35% higher than the 5-star 2023 5-star rate. So the version that left the Senate was 38.5%, and this is 35. And then we have language that there's sort of distinctions made by provider type. Next is the appropriation section for the fiscal year 24 changes that we looked at so far. So we have the, oh, are you looking at draft 1.1? Okay,
Yes.
We printed it.
you are. What, you printed it?
Yeah.
Okay, so this is the only change from 1.1 to 1.2. So the number on line 10 should be 47,800,000. So this amount is for the family expansion from 150 to 175 with no copay, and from 350 to 400 participating. Covers that, and it also counts for the base adjustment from going up to the 5-star rate, and then the 35% on top of that. And then you have an administrative appropriation to CDD, that's 4 million. I think it was 6 million when it left the Senate. And this will cover 11 new permanent classified positions within CDD, and those are listed there. Of this 4 million, 2 million is appropriated to the community child care support agencies. And then you have your readiness payments. This looks very similar to what it left. I'm trying to think, I think we were around 21 million. It's like 25, okay. I rounded down, I guess. Okay, and this will be 20 million as written here. And then we have a list of how the payments can be used. And you'll see at the very bottom in subdivision H, on line 20, we have a catch-all. So it's very flexible money. Subsection B is sort of new language that's worth flagging. So there has been a conversation upstairs about that the agency of the administration might be adopting a bulletin or amending a bulletin in the near future, which would have the effect of slowing down the payments going out the door. And there was a concern that the readiness payments contemplated in this section wouldn't move to providers quickly. And so what this language does is directs that the division is to utilize the bulletin pertaining to beneficiaries that's already in effect on May 1, 2023. So don't use the bulletin that's about to change, use what's already in effect. And the hope is that that will have things moving out the door to providers a little bit faster. Next, we have section 9 and 9A, and those amend the same section twice. Excuse me. The first time, so this has to do with provider rates. We've already looked at money to readjust the base. This is language that sort of contemplates how are the rates going to be addressed on an ongoing basis every year. So this language says that the payment schedule is to account for the age of the children served, and it's going to be dependent on the type of setting the provider provides care in. That's very similar to the language that left the Senate. And subdivision 2 at the top of page 22, the decision has been made that payments in CCFAP are based on enrollment. That was the same as what left the Senate. The House in their contemplation added language asking the department to define what enrollment would look like and the total number of allowable absences. And then both versions were decoupling stars from payments. And that's what's happening in subsection C. Section 9A is amending the same section again. So let me back up. Section 9 takes effect January 1, 24. And then section 9A takes effect July 1, 24. So on July 1, 24, there's this sentence added on page 23 that basically recognizes that there is a differential in how center-based care and family childcare homes are reimbursed under the CCFAP program. And it says, so after you've sort of determined the rates for these different provider groups, the rate will be further adjusted for family childcare homes to close that differential by 50%. So that takes effect July 1, 2024. New language that is just being introduced in this new version is a report on how the adjustment of CCFAP rates should be conducted. So this language is that by this coming January, CDB in collaboration with JFO is to submit a report to the various committees providing recommendations on the appropriate mechanism for adjusting future reimbursement rates for childcare providers participating in CCFAP. Second, the appropriate reimbursement rate in fiscal years 25 and 26 for childcare providers participating in CCFAP. And lastly, the appropriate family contribution in fiscal years 25 and 26 for families participating in CCFAP.
Did you see why it was highlighted? Is that it?
That is, it's new language that is unique and original to this draft. So this hasn't been moving through the process yet. This is the first time this language has been added.
Where did it come from?
No, the bill that we passed has built in sort of a automatic escalator and reimbursement, which every provider would like to be treated that way. And so we felt just for the sake of consistency across provider groups that we would use this as a replacement to simply say one particular group of providers was going to be treated differently than everyone else relative to rate increases.
Okay, so in other words, came from. Okay,
It's reflecting our standard practice.
Section 10 on page 24 and 25. This is the Child Care Quality and Capacity Incentive Program. This is, language that if the funds are available, consistent with the funds appropriated, that there are these incentive payments if certain achievements are met. Those achievements are listed on page 25. And this is a very similar concept to what
We wanted to be able to have something to recognize the quality. And if you're moving away from stars.
Moving away from stars, so you need to have some incentive to step up the ladder.
Next, section 10A is just legislative intent language, but it says that it's the intent of the General Assembly in fiscal year 25 and in future fiscal years that 10 million is appropriated for this quality and incentive program. Next, section 26.
Application fee.
Yeah, so
We had that.
this is the only section in the whole bill from introduction to now that hasn't changed. So this section is a survivor at
I
this
guess
point.
we still like it.
Yeah, so the idea is that you, provider can't charge an application fee or a waitlist fee to a family that would qualify for CCFAP. Section 12 would take effect January 1 of 24. This is first language that a provider shall ensure its tuition rates are available to the public. But then language that a regulated childcare provider shall not impose an increase on annual childcare tuition that exceeds 1.5 times the most recent annual increase in the NAICS index. And that amount is to be posted on the department's website. Then,
And that was in your bill, Senator Rollins,
Pardon me?
the tuition rate capping it on the.
There
increase.
was different language, and so we modified the language so to offer clarity, so.
next is a section on the disclosure of ownership. So pages, the bottom of 26, all of 27, we have.
Katie, before we move on from section 12, a regulated childcare provider shall not impose an increase on annual. So we're saying that they could every year as a matter of policy raise it 1.5 times that as a standard practice. That would be within their allowable.
Yeah.
I think it was probably in response to what was a very
It's the
huge.
above part, the certain category of childcare providers who are raising their rates really high.
Understood.
So this is.
Should that be looked at after a given period of time or cap put on that?
Well, I have a question about that. What if you have a program that's licensed but does not accept any children under the CFAP or this expanded program? Would we even have any jurisdiction over?
They still have a license from DCF.
So it would be a condition of the licensing.
Language would
That's how we
capture
would enforce it. Okay, I was just wondering. Senator Burton.
When that last sentence in that section, this amount shall be posted, that's the amount referring to 1.5 times that 611 NICS code.
Yeah, the rate. The tuition rates.
All right, so we're through what, 27, the orange section 12A.
Yep.
Um,
So we have a series of definitions, all of page 27 is definitions, but what this language really does is on page 28, subsection B, line 8. The department is to adopt procedures to require each applicant for a license to disclose prior to entering a provider rate agreement the type of business organization of the applicant, the identity of the applicant's owners and principals, and the identity of the owners and the principals of the applicant's affiliates. And then we have language beginning on line 15 that the department is to consult with the Office of Racial Equity in preparing all public materials and trainings related to CCFAP. In 13, we have some rulemaking language that the department is to amend its rules to require a program director present at the childcare facility, that the director operates at least 40% of the time that children are present. And then we list the center-based rules and the after-school rules. In subsection B, this is not directing an amendment, but it's directing the department to review and consider amending. First, in subdivision 1, it's rule prohibiting a person or entity registered or licensed to operate a family childcare home from concurrently operating a center-based childcare preschool program or after-school program. So right now, a family childcare home operator can't concurrently operate other programs. So this would allow concurrent operation, assuming they consider and decide to amend. And then similarly, we have language that the department will consider amending eligibility policies addressing self-employment and other areas of specialized need on a regular basis, and revise them consistent with research on best practices in the field to maximize participation in the program and minimize undue burden on families applying for CCDAP. Language around background checks, as I'm sure you're familiar with, if there is a provider providing child care services in a public school setting, that provider might be subject to sort of 2 sets of regulations regarding fingerprinting and background checks. And it creates a bottleneck to have to go through these 2 sets of regulations. There's been a lot of attention on this, and there hasn't been a resolution to date. And so this language asks for the necessary parties to come together and look at how to streamline that.
And the fingerprinting is just basically included in background checks.
I
You don't have to
believe so.
mention.
What was that?
You don't have to mention, because I've heard that's been the fingerprinting has been one of the main. Well,
I believe we use background checks to include that, but I can clarify if you're interested.
Sure.
Okay. Section 16. So this is special accommodation grants. You also had a report on special accommodation grants. This is asking for a plan. There weren't very many changes to that particular section. 31 is workforce supports. So in Act 45 of 2021, you enacted the Student Loan Repayment Assistance Program. And at that time, you set a sunset of July 1, 2026. The decision here would be to remove the sunset so the program becomes permanent. And then in subsection A, that's just a conforming change. Language in section 18 to have a presentation on the feasibility and progress of establishing administrative service organizations for childcare providers to sort of pool administrative resources across multiple providers. There was also language on technical assistance that was in the Senate version. This directs Building Bright Futures to have various monitoring and technical assistance responsibilities, defining the measures of success and various benchmarks, and that is on page 32. We have a corresponding appropriation in section 20 for Building Bright Futures to do that work that comes out of the 4 million in section 7. Section 21 is the second piece of that plan or concept that we talked about at the beginning of how to elevate the child care and early education within state government. So this focuses on DCF. And then, did I get to the end?
It'll be on wages on 30.
Oh, okay. Page 34. Wages. I'll switch out Damon.
Good afternoon. For the record, Damon Leonard, Legislative Counsel. So section 23 is an intent section. It says that the intent of the General Assembly is that when the provider reimbursement rates reach the level recommended in the RAND report, then Vermont might or may establish minimum wage rates for childcare providers that align with the recommendations of the Association for the Education of Young Children's recommendations in the 2021 Advancing ECE as a Profession Task Force, and that those would be annually increased based on the average wage in NAICS Code 611, and that they would be adjusted for inflation based on the JFO report in section 24.
That's really warm and fuzzy.
Yes,
I said it's really warm and fuzzy.
Yeah, why the permissive language? I mean, I understand we can't direct future legislatures, but this Vermont may do anything, right?
Do you want to speak to it, Katie?
Do you want me to help? Can't speak to legislative intent, but the conversation in the committee when they were looking at that was that it's helpful to sort of, yeah, that they wanted to sort of give a roadmap of what the thinking was of next steps. And so that this sort of gave an indication to the field of what the next steps would potentially look like. So that was the conversation.
It's also difficult to establish wages for organizations.
We don't even do it for
Right.
public education.
Right, so
schools.
it's a
But-
may. It's looking at the data and sorting out what maybe in the RAND report, there was a proposal for a wage, incremental wages based on education. However,
Yeah.
these are private entities, so.
Yeah, it's worth noting that we can do this, and we have done this in the past, just not in my lifetime. So, just to be clear, and our neighbor to the west, New York, does this periodically as well.
When you say this, do you mean writing this language or
No,
fixing?
setting up wages for specific occupation, saying we're concerned about, we want to set a floor for wages in an occupation because we're concerned that the rates may be,
So,
at some providers are not high enough or
so I
something
want to
like
go
that.
back. These sections here, getting into wages and, et cetera, that came out of Ways and Means. That was not in,
This is a Ways and Means recommendation.
217 or just that child care?
no, this is just childcare.
This is-
We haven't gotten to
this is-
217
Yeah,
yet.
217 is still,
But we did have language about an analysis
Yeah,
for wages. We did have that in our bill, and they've taken it and expanded it to have a more of an implementation.
So the question is, do we want to import that level of detail
right.
in our version?
And my problem with it is, we're saying it's the intent, and then we're saying these things might happen. So if we're saying it's the intent, why wouldn't we say it is our intent that these things will happen? Understanding that future legislatures might not do them, but now it's saying it's our intent that we may do these things, but that's not specifying intent, that's specifying capability, really.
I would agree
Our
with you.
intent is that we don't have any intent.
Right.
Really what we're saying.
We might have it.
Well, I guess the question
That ain't
would
gonna
be
get
whether
food on the
in
table.
this version that is really to sort of parallel to some extent what we had passed, do we want to get into these sections that came out of Ways and Means specifically?
To me, if you're gonna write something like this, and traditionally, childcare wages have been low, Vermont needs to step up, something of that nature, which is brief. This is just,
Oh, I was gonna say, maybe we could go back to, we'll take a look at what we had originally. Obviously, we would hope with a 35% increase in reimbursement and moving from 17,000 up to close to 24,000 would have a positive impact on wages.
That's the intent.
That is our
That
intent.
is the intent.
So I'm gonna suggest maybe we take these sections and just look at what we had previously and not attempt to get into what Ways and Means and how
23
we
and
added.
24.
Yeah,
This wasn't in the discussion that I have had with take care of human services.
Okay, all right. So, shall we keep going with the childcare contribution? And-
Yeah, so 2024 is just a report on estimated current minimum wage levels and data regarding wage levels for early care and education providers.
But we'll take a look at that.
Yeah, so that would be related.
And now we're into how we were going to finance.
Yeah, so this is the payroll tax, which is now called the child care contribution. And so this replaces the child care and parental leave contribution that was in your Senate version. This is essentially identical to that with two changes. The first is that the wage base has been increased to 2 times the amount of the Social Security contribution and benefit base instead of just the Social Security contribution and benefit base. So instead of being 160,400, your cap on taxable wages is 320,800. So it expands your tax base.
Although there aren't too many, we have a smaller number of employees, I'm sure, at that wage rate.
Yeah. The other substantive change, we do the same thing on the top of 37 for self-employment income. And then on line 10 of page 37, the contribution rate is up to 0.43% instead of 0.42% based on the latest projections from JFO, given the slightly different revenue picture here versus what was in the Senate.
Well, I think it's important to remind the committee why we're having a change. One of the, in attempting to come to some resolution with the other body, we had parental leave, which we've agreed to not include, and we are very sad to see that provision negotiated away. And the other part was preservation of the child care tax credit that was refundable, that was put in place last year. So when our finance committee was looking at the revenues that needed to be raised, they were redirecting about 32 million from that new tax credit program to support a lot of the rationale for doing the child care tax credit was the cost of child care. But we concurred with the House to keep that tax credit in place. So that obviously having a reduced revenues are impacting in a very modest way. I think it was 0.42 maybe.
Yeah, it's 1/100 of 1%
Yeah.
change.
So that's the reason we're dealing with it a little bit different rate here.
But even with that increase in the rate of taxable, people will still need to go up 1 point.
Yeah, so it's at 1/100 of 1 point. So, yeah.
If it was
So
1 point, it would
Oh,
be.
no, we wouldn't be.
Yeah. So it's a very, it's a slight change. And yeah, so, and Patrick Titterton from JFO can speak to you more about the specific numbers in that estimate, but that's the slight change after leaving in the child tax credit and making some other adjustments. So, the rest of this going up to the SALT deduction cap workaround on page 39 is, except for changing the title of the payroll tax, it's identical to what you passed already from the Senate.
And Damien, where is the payroll tax specifically?
It's the child care contribution.
It's now.
Okay, so it's section.
Starting section 25.
Yeah, section 25 and 26 are the contribution. So section 25 creates the whole new chapter with the contribution. Section 26 provides the positions and $4.2 million to the Department of Taxes to implement the collection mechanism. So that's for IT and other programmatic development.
Yes, center month,
What's the effective date for that? Is it July 23?
July 1.
Yep, it's a July 1 effective.
Mhm. And the tax department needed time to program a new line of. The salt is something that we passed out earlier, and we actually assumed that that would have a benefit of 500,000.
As a retroactive.
Yeah, so we assumed that, and so this is the deduction is something that we've already passed through the Senate.
On a separate bill.
What?
It was in a separate.
Yeah,
bill.
it was in a separate bill. But our Senate finance is hopeful that that would be included. And then, so this is all related to salt through to
Right, and that's Abby.
What's all 10 for again?
state and local taxes.
Thank you.
Yeah, and that brings us, we jump ahead to page 45, that brings us to the actual underlying bill
To jump ahead.
that we're amending. So we're starting on section 30. So section 30 is our annual, we do this every year, we set the contribution rate for the workers' comp administrative fund. It's a surcharge on workers' comp insurance premiums that funds our state's program, just to keep it the same as last year. Section 31, because every single year that I've been here, the workers' comp administrative fund gets put into a bill that either has a poison pill in it or suddenly becomes controversial at the last minute.
We don't want to disrupt that tradition.
Because of that,
Good.
section 31 is adding a default provision in
Yeah,
the
we don't
event
do
that
it,
the
it
bill doesn't
continues.
pass, that you default to the existing contribution rate. And this, I should say, this is a Senate position that dates back as long as I've been here. The Senate has been asking for this to be defaulted to an administrative rate setting with a report.
And finally, the
And this
House
is-
has agreed.
Well, this is a compromise position where if we can't get it across, it'll just stay the same. So at least the program is funded.
What is it?
So it's 1.5% on direct calendar year premiums.
That's what the existing is now.
That's the existing, that's what it's gonna stay at for the coming year.
So either way, 1.5%.
Yeah, so either way, even if this language passed and we didn't adopt the new language, it would still be at 1.5%. This is what, in the 9 years I've been doing this, it's been 1.4, 1.5% every single year. So it rarely changes that much.
So this language that I'm looking on page 45, that's what you're talking about. So
We have to set that rate every year because of the way the statute is set up. The Department of Labor has to come to the legislature with a proposed rate, and then it has to go through in a bill and get enacted.
but if this bill doesn't pass, then this language obviously doesn't.
Yes, so we do need to get this one across the finish line
So
this
we'll have the
year.
default language.
So that the default language is there next year.
Right.
But we don't have default language yet. This bill would add it in, so just in case for the next time around.
Which makes this bill something more of a must pass.
This is a must-pass provision in here, the workers' compensation and
That's
safety
due
division
for
at
Is that in
DOL.
the budget bill?
The entire workers' comp program is funded through
Where do you
this.
put this line?
This is a separate bill.
So,
It's not in the budget. We're moving it separately.
I understand that, but.
He's
the
asking
bill
the way the
fails.
workers' comp language
Oh,
in the
oh.
miscellaneous
Where do you
bill
put
is here.
this?
Okay,
Because how do you make this law if the bill fails?
Well,
We have to.
So-
exactly.
yeah.
So what's the budget?
I see.
The other place that it's ended up periodically in the past is in the miscellaneous tax bill. It's gotten dropped in there.
Which is
So,
still next door.
right, so, but this is a must-pass provision. The section 54B, this section we have now had
We just jumped.
50, oh, I'm sorry, not 54B.
Oh, it's
Section
32.
32, amending 54B from another bill.
Oh,
It's been a long day, I apologize.
no, I'm.
Section 32, this is amending,
I was thinking you were
Me
really
too.
moving right ahead.
no,
Oh,
I wish. So this is
Yeah, we
amending
do
a
too.
sunset from 2015. This was a trial with the workers' comp program, allowing claimants to request a 14-day extension if the insurer proposes to discontinue their benefits. After an 8-year trial, it's agreed now that this should be made permanent. So that's all this is doing. It's adding back in the language the sunset would have taken out. Section 33, this is for pre-authorization of benefits and workers' compensation. The current law allows pre-authorization of medical treatment, but not things like prescriptions and durable medical equipment. This would correct that. Section 34 sets parameters around the work search requirements for individuals who are partially disabled. So they're still able to work, but they can't do their regular job. Section 35 amends the temporary partial disability benefits. There's an issue with the formula where lower income individuals actually lose money if they return to work, which is obviously a disincentive we don't want in the law. This fixes that issue and also provides a trial dependent benefit at that level of $20 per dependent. Section 36 sunsets that dependent benefit in 5 years. Section 37 increases a dependent benefit that's already there for temporary total disability benefits, meaning you're unable to work, and also provides clarifying language around cost of living adjustments. And Section 38 sunsets the trial increasing the temporary dependent benefit. Section 39 is a report back on that dependent benefit increase to look at the impact on workers' comp rates. Section 40 is clarifying language around cost of living adjustments to eliminate confusion around permanent and temporary workers' compensation benefits. Section 41 is clarifying language around when attorney's fees and costs are available following proceedings related to workers' comp disputes in front of the Department of Labor. This reflects existing law and department rules and practice. It's just codifying it in a more clear manner. Section 42 is rulemaking. Section 43 is adding inclusive definitions of son, daughter, child, and spouse for unemployment insurance purposes. Section 44 is effective next year.
Can you go back to section 41?
Sure.
41.
Yeah.
Yep.
That should go to judiciary. You really, commissioner may award reasonable attorney's fees. The commissioner,
This is
the claimant
existing
prevails?
law. It's just being,
why is it underlined?
because we've taken the existing law and we've rewritten it so it's more clear. Because there was confusion between the department's rules and the statute on the books. So there is no change to existing law in section 41. It's just being clarified.
So it's existing law.
And it's for administrative proceedings at the Department of Labor.
Understood, but it's
So
when the commissioners are able to award, who's paying when the commissioner awards these?
this would be the insurer whose the claim was disputed with.
Is the clarity, the stricken language in A too?
So the stricken language at the beginning in A and then at the end in D on page 59 So in cases for which formal hearing is requested and the case is resolved prior, the commissioner may award reasonable attorney's fees.
And that's current statute.
This is current statute, and then it reflects also current rules and practice of the department. It's just laying it all out in clear language that's grouped together in the statute. There were complaints that were brought to the Committee of Jurisdiction's attention by practitioners in the field that there was a lack of clarity about what was permitted when, and they wanted the statute to be more clear. So,
About the questions or?
No,
That
I
I-
disagree with it. I wasn't aware that the current policy.
Current law. Current
Current
law,
law.
yeah.
Well,
so
but it looks good to me.
Shall we keep going, or do you want to take some other comments?
sure, so section 44 would extend, beginning July 1, 2024, would extend unemployment insurance. Right now, it only applies to nonprofit employers with 4 or more employees. This would extend it to all nonprofit employers.
That was a lot of people got surprised with COVID that they worked for a nonprofit and they had no benefits.
That's exactly what it's addressing. The 1-year delayed effective date is to help nonprofits prepare and budget for the change. Section 45 is another section where we're making technical changes.
I'm
without
sorry, but
changing-
who's paying the bill for this?
For what?
Workers' compensation?
The workers' comp is now required of those that have less than 4 employees. Who's paying the bill?
I'm sorry, so we're talking about unemployment
The
compensation.
unemployment, who's paying the unemployment tax?
Employers, so employers pay the bill for
Right.
unemployment compensation. When you're a nonprofit employer, you have the choice of either being a taxable employer, meaning you pay a payroll tax on the first roughly $15,000. Or you can reimburse the fund for your unemployment insurance
So
liability.
this is gonna cost small childcare agencies more money.
If they're a nonprofit with fewer than 4
Well, I
employees.
imagine many of them are.
Nonprofit? Family daycare?
They have to be, yeah, so it's a nonprofit with fewer than 4 employees, then they could potentially be liable
This
for
would be any
unemployment
nonprofit
insurance.
in the state.
Currently, all nonprofits with 4 or more are covered by this.
Yeah, I know, but
But this would be all of the nonprofits with fewer than 4.
all nonprofit organization
Yes.
is now gonna get hit with that.
If they have unemployment insurance liability, so if they're a reimbursable employer, they're only hit with that if they have unemployment insurance liability. Meaning that someone who they paid wages to in the last 5 completed calendar quarters goes out on unemployment insurance, and then they pay their proportion. They pay an amount that's proportional to the wages they paid to the employee in that period. So if they paid 20% of the employee's wages, they pay 20% of the employee's benefits.
Liking the underlying bill less and less. Thank you.
Well, we do have presented the bill from economic development as well, so I'm sure that we need more information. I know that this was in response to a number of individuals who discovered that they had no protection for UI benefits because they were employed and they had not been notified. They did not know that that was not an employment benefit that they had. So, shall we, do you have anything more, Senator Harrison, that you want to add relative to any of the discussion in your committee?
I just want to add, it's section 3 on my old form, which I think is section 33, about the sunset provision with the 14-day extension. That is important to keep.
No, we're on page, we're on 45.
Right.
Page 64.
Well, I think it's,
He's on the original bill.
I wanted to add something on a different.
Oh, okay, yeah, they're concerned about 14 right now.
So you have
Here's
more
what we're working on.
experience. I thought that there were employers who had to pay back unemployment benefits and they were surprised also, or was that a different condition?
So during the pandemic, and that gets to a later section, and here there were nonprofits and municipalities that were also surprised by their liability, particularly just given the volume of unemployment claims, and that's addressed in the next section, which is section 46, requires the Department of Labor, working in consultation with the League of Cities and Towns, Common Good Vermont, United Way of Northwest Vermont, and other interested stakeholders to develop education and outreach around how the unemployment insurance system works, how to budget for potential liability, and your options to either be a taxable employer, meaning you pay a percentage as a payroll tax, or be a reimbursable employer, and budgeting for those, because as a reimbursable employer, you do need to set aside money for that rainy day.
We're back on, up to page 77. where
So this is up to 75 here,
Okay, hon.
and then if you skip ahead to, yeah, so that goes up through 75 to 77 is that outreach program, which requires printed materials, working in consultation with the Secretary of State to reach all the nonprofits in the state, providing outreach events that are, or an outreach event that's in person and virtual and recorded, and then working with the various stakeholders to also push out the information so that the maximum number of potential.
What's Common Good Vermont?
Common Good Vermont is a nonprofit that was established to basically help nonprofits navigate the environment. So they're affiliated with United Way.
And they are, thank you.
They are a nonprofit themselves,
They have more
and
than 4
they,
employees.
I believe they do. So,
Thank you.
yeah.
That was meant to be
But I'm not allowed to be common here. I have to be very serious.
Oh,
I'm sure I will now.
sure,
So,
sure. Right up, you'll be getting emails, love notes again.
Oh, I know. I've gotten so many of them today. It's just incredible.
I
People that
know,
are
I'll never
in love
vote
with
for
me.
you again.
I know, he's from Bristol and he'll never vote for me.
I tried to help you.
All right,
All
let's
right.
keep going. You
So-
realize it's 5:15.
yep, section 47 is correcting an arithmetic error in the compromise agreement for supplemental unemployment insurance benefits from last year's unemployment program. This was something that the Senate had pushed for in conference. And because of the way I had done the math and the language there, the department, when they were looking at the implementation, realized that I had not counted a few $1 million. And so this is correcting that error.
It's only 8 million, that's not much.
No, so it actually, it could be as little as 2 or 3 million. It could be as much as 10 million. It's variable because the way the unemployment insurance program works, you change the benefits once every year. And so if we hit the sunset right after the benefits change, we wait a year, and so we have a year of extra benefits paid out. And this will count that time and make the adjustments. Section 48 is a study requested by the House on possibly expanding unemployment to cover instances, urgent instances when an individual might need to leave work because of an out-of-work injury or illness, injury to a family member, to escape domestic or sexual violence, having lost childcare, something along those lines. Other states provide coverage for some of these instances, and this is looking at what it would cost Vermont to do the same.
That's an interesting word, new word.
necessitous.
Yeah.
It was taken from the statutes in Massachusetts. They are very creative with their words down there, so.
I don't even know if I can say it without lisping. But.
That's why I say urgent. And just leave it at that.
Right.
So sections 49 and 50 relate to a UI adjacent program, the Domestic and Sexual Violence Survivors Transitional Employment Program. This is for individuals who are unemployed because of domestic or sexual violence. They don't qualify for unemployment insurance. The Department of Labor has been working hard in recent years to increase awareness of the program and increase usage. And this is asking them to provide a report on the efforts they've been making and to identify any additional efforts. And then section 50 is requiring additional work to provide outreach with groups from the state's attorneys to victims advocates. And then section 51 gets us to the effective date. So I will yield the seat to one of my colleagues.
How about, I would like to just say a couple of things.
Sure.
Sure.
Back on page 46, in section 32, it deals with discontinuance of benefits. This is a section that is important to make it through the process because it cancels a cancellation of benefits
So this
that
is
are
the second
important.
reason why this bill has to be passed.
Yes, but actually I want to just provide a different perspective on the first reason why we think it should pass. But this one is important. I just wanted to point that out because right now there's a process that gives the injured worker 14 extra days to get information, and that's been around for 8 years and is really important. So I want to point that out. And then making the bill not a must-pass bill does reduce some of our leverage. So I would see that as the reason not to easily make it a not-pass bill.
We think it is a must-pass bill.
Well,
And it's.
okay, let me rephrase that. Taking away the automatic calculation of the increase makes the unemployment compensation bill not a not-pass bill. But while it is a not-pass bill and the must-pass, I'm sorry, thank you. While it does contain that language, it is a must-pass bill, which gives us some leverage.
Okay, so we have two parts, one of which is the 14-day that's been in place for 8 years.
Yes.
And the other is the language that if we fail to act, the previous rate remains in effect, which we would like to put in, and then we wouldn't have a problem out into the future, but right now we don't have it. So in the absence of that provision, we must pass.
And also,
Yes.
I'm assuming if you don't pass this first section on page 45, there is no rate.
There is no rate.
That's right.
So
That's why it's a must pass.
right.
That's the motion.
I don't know how many workers that affects, but it means the entire workers' compensation program would be unfunded for a year. There is no funding stream for them besides that I'm aware of. So,
Yeah, but just to clarify, that's not the workers statewide, that's the workers in the labor department that administer the program.
right,
I just, when we say workers, let's be clear.
yes.
Other questions or clarifications? We know that we probably need to make a few modifications with the whole discussion on what.
And we do want to return to one section, which is the pass-through entity salt piece, because we were under the impression that was the same as past the Senate.
Oh, it's not. Okay, so we have Abby who's gonna walk us through that.
And kind of start around the numbers.
We also have Councilor St. James for that education question.
So
We
the
want to get
education
there.
piece, but
Yeah, and I
our
think,
ed committee probably should.
well, either that or we go back to maybe our original language around that's an area for examination, and I can't
We're
remember
talking about the
exactly.
wages.
No, I'm
No.
talking about a 4-year-old.
Oh, the poor.
And the
yeah.
language they had in our bill that we passed, because Senator Bruce is commenting about the level of specificity that's now there in sections 3,
Page 10.
and 3A.
Right, if I might, Madam Chair. So my thinking is that we could strike section 3 and 3A. They, like the intent section, that then becomes a series of mays. This one makes a change in the weight formula, but says it won't happen until we pass legislation, and then it lays out 3 things that we must do, which we can do without these sections. So they are meant to push us in a certain direction, but it's a direction that our education committee hasn't taken testimony on or weighed in on.
So it would be perhaps prudent to go look at our original language that
Yes.
we had, because we're concerned about that very issue.
Right, so I would move that we swap these 2 sections for
With our
our.
earlier language.
Sections 3 and 3A on page
Yes.
10 and 11.
Actually, our original language might also, the study that they
The
have,
wage study.
they call it the implementation plan. That's, I believe, that's section 2. That, I believe, our language did differently. So it might be that section 2 as well would be pulled and replaced by our original.
Okay,
We can take a look.
Does that make sense, Katie?
the section 2 does, and does section 3 and 3A make sense to you, Beth?
St. James Office of Legislative Counsel, so we're talking about S56 at this point?
Yes.
And the version as passed by the Senate?
Yes?
I don't believe there was anything corresponding to sections 3 and 3A.
No, I'm just saying pull those and then replace section 2 with our original language.
Yes, that makes
That
sense.
makes sense?
Yeah, I think. Okay, so now we're back to the SALT.
Yes.
Okay.
Thank you. So for the record, Abby Shepherd, Office of Legislative Counsel. This language was passed out of the Senate in a very slightly different version that does have a very small revenue impact, and I will defer to JFO to explain the difference. So in a very short version of what this language does, and I'm sorry, it's on page 39. It starts on section 27. And it's the asterisk there, I named it salt deduction cap workaround. It's actually an elected pass-through entity income tax and credit. So trying to make it a little briefer, I'll just refer to it as SALT. SALT actually stands for state and local tax. There's a deduction at the federal level, and this is a way, following the Tax Cuts and Jobs Act in 2018, that restricted that itemized deduction to a dollar amount of $10,000. This is a way that states have found to create a workaround so that individuals who are members of pass-through entities can still take a full itemized deduction for state and local taxes. So the way it works is if a state passes a entity level tax for pass-throughs, these are S corporations, LLCs, partnerships, not C corporations, their members are able to take the federal benefit by having a full itemized deduction. Additionally, the state provides a credit against this new entity level tax. So the individuals are then able to take a credit, which in the Senate version, which was S45, was a 90% credit of what the entity had paid. In this version, and I can change it back to what the Senate version was, in this version, which is what the House Ways and Means Committee has been considering as an amendment, it's an 87.5% credit. So it does actually increase revenues slightly. And again, I defer to Jeffo to tell you what that impact would be. There are also some slight changes to the types of individuals who will be able to take their credit. So it is slightly different. That is more of a technical change compared to the Senate version. But otherwise, so this is only in effect while the federal cap is in effect, which started in 2018 and is currently set to sunset at the end of tax year 25. So this language would be repealed either when that takes effect or if there is any, there have been different bills proposed federally to extend the cap. So whenever the federal repeal takes effect, Vermont's workaround would also be repealed.
So I guess we need to check with our chair finance to see if they have an opinion about which rate, whether we stay with what they passed. I know I've been hearing from members of the committee, don't let that, keep that provision, make sure it happens. So that's why we were including it. And obviously there is a revenue impact that we've assumed, so.
Well, we haven't assumed a higher rate at this.
No, but we did assume the 500,000.
So if you want to understand what the
Yeah,
rate
what-
that's in there, that's your.
Yes. Do you wanna, why don't you stay right there?
Okay, sure, yeah.
It'll be
Makes it
easier.
complicated. For the record, excuse me, Ted Barnett, Joint Fiscal Office. Yes, so we are anticipating with the 87.5% credit, that generates $1.7 million worth of revenue. By lowering the credit, effectively the state is keeping a little extra of the pass-through entity tax. And so it generates an estimated $1.7 million annually.
Total, so the 500,000 is part of the 1.7 or additive?
It would be a total, or it's a part of that one.
So it's 1.2 more than what.
Yes.
All right, that's really what I'm asking. Well,
And what's the difference? What was that, 90%?
90 versus 87.
Yeah, so that's, what was the revenue in 90 versus 87?
500,000 and 90,
Okay.
and by dropping it down,
Okay.
it moves from 500,000 to 1.7. Other questions about, I don't know whether finance is still meeting or not. Why don't we talk to Sure, she may change her mind.
Be careful what you say yes to. Where do you want?
I guess.
Right
Oh,
there?
sit down and make yourself comfortable.
There I am, oh, yes, you're
That's a
comfortable
nice
chair.
chair.
So Senator Cummings, we have a bill here that we are amending. It's, and to include our childcare program. And moving forward with the revenue source that we had in the bill, S56, as we passed. And there was concern and a desire on the SALT deduction cap to not have that fall through.
That I'm already planning on putting on miscellaneous tax.
Okay, so we don't need to put in here. That was my question. And I think Senator Chittenden had mentioned something to me, and I said, well, the chair could
Yes,
do
no,
it.
he's been mentioning, no, that one, it may go on there and on S94 too.
All right, so we don't need to include it
Yeah,
here
no.
because there's another
No,
bill.
that was not in our original bill.
So what section is that?
That is section 27.
Okay.
Yeah, so I guess we can take
I'm
that
gonna
out.
get out of
The difference is, do you agree with the House version? That would generate a bit more revenue. We had 500,000 at
Oh,
your
for
90%. And yes, and they've
We
lowered,
haven't even looked at it.
well, that would
so-
generate 1.7.
Okay,
So,
we will take a look at that, before we speak it on. But that was my intention.
thank you very much. You made our life a little bit simpler.
You're making mine a lot simpler.
Thank you.
Okay,
So,
I'm going home and catch.
so
me
we will
again.
remove that section, because it's.
You have to also remove 28.
And, I'm sorry, Andy.
It's section 28, does that go with it?
Anything related
Credit
to
for
salt
taxes.
pass through, yes.
So 28 and 29.
27 through 29.
I think so, yes, right through the repeal is 29.
I did
Yeah,
that one.
so-
I knew what-
Yeah, you did, yeah.
You're so smart.
You
Yeah.
thought I was asleep.
I never question. He who watches over us slumbers not or sleeps. Okay, all right, so we'll take out those sections. And so we're removing 3 and 3A, we're putting back
Our language in
our
section
original
2.
language, we're removing the salt language. And the, what the way,
The wage piece that was ways and means.
The way-
yeah, those ways and means
Yeah,
section.
there was we had a study in one.
And so you're placing that with the study that was originally in the Senate bill.
Yes,
No,
I
we're
think we
taking all
should,
the
I think we
study
should adhere as much as we can.
Right.
It's mostly.
I know.
Well, our mom, we have a, if you can't fund it and study it, that's what we are gonna have as our operation.
Analysis.
Any other questions? So we have amendments, to our amendment, and so we're gonna have to wait for that, to be incorporated. Time-wise,
Bill,
you want us to,
Madam Chair, are you thinking of a vote based on our understanding of the amendments?
yes,
In which case, if you would look favorably on a motion, I would move that with the stated amendments, we pass out H two
I
seventeen.
think we need to vote the amendment with the modifications first, and then we will move the bill favorably as amended.
Okay, so as you just stated.
second,
Okay, we have a motion made by Senator Ruth to move the amendment, which is related to the childcare section, favorably with the changes that we've identified. A second by Senator Perschlick. This is on the amendment.
We actually have possession of the bill.
Yes, we do.
Good.
Very important. Have it, H bill.
I understand the importance of having an H bill to the very last moment.
I bet
I
you,
just wanted to make sure it was still in.
yes, it's still, as of this moment,
Yeah,
yes.
okay,
So we,
well,
Senator by
yeah,
Senator,
I got it.
okay.
So, did you
this is
know
the amendment.
the wage pieces? It's 3A, 27 through 28, and what were the
Right,
other?
29.
29.
And 29.
and then we had,
Section
the
27
wage
through 29.
when we
And
also,
was
And
the
the
section?
wages were,
Maybe Damien can say the wage section.
which section?
So the wage sections were 20, 24, 25, hold on. The 23 is the wage intent section, and then 24 was the wage report by JFO. Are you deleting one or both of those?
Just delete both and
And
replace
replace it with
what-
section 11 from what passed the Senate, the
Yes.
wage, the
Yes.
compensation
yes,
study?
yes.
Okay,
So we're deleting 3A,
We're replacing
27.
two, I think, as well.
27
Replacing
through
section.
28, and 23 and 24.
And replacing section 2.
Swapping hours for those.
You're
Yes.
replacing section 2, you're deleting 3 and 3A. You are striking 23 and 24 and replacing it with the former section 11 of that's 56 that passed the Senate. And then you are also deleting 27 to 29. So I think you have what you're doing.
Now, I'm gonna write that on here
Stephanie
eventually.
Stephanie can give you.
Yeah, if you could give me that.
So
already.
I'm gonna have the clerk call the roll on the amendment, and with the changes that we've just, so,
Senator Brooke,
Yes.
Senator Lyons.
Yes.
Senator Pershing.
Yes.
Senator Sears. Senator Starr.
Yes.
Senator Westman, yes. Senator Kitchell.
yes. Now a motion to move the bill favorably as amended by Senator Ruth, second by Senator Burchett. Are we on overtime?
Yeah, we used to. do that.
Time and a half.
Oh.
We get time and a half.
That's about
here.
time.
We've always.
Anytime after 5, we get time and a half.
Oh, yeah.
Somebody has to have a bill.
Ruth and me,
So, we need to have the clerk call the roll and then we'll decide the reporter.
I'll make clear that we do not get paid extra for being here late. Since somebody might have believed what I just said.
do people believe what he said?
Some do,
Just feel lucky when you get.
not my wife.
Senator Brooke,
Yes.
Senator Lyons.
Yes.
Senator Pershing.
Yes.
Senator Sears.
Yes. I don't like the underlying bill though.
Senator Starr.
Yes.
Westman, yes. Kitchell.
Okay, now we need to have a reporter from this committee. And I'm thinking probably Senator Lyons as the You can do the first part. Yeah, and then.
You're on as the reporter. If you want help, enlist them.
And because obviously, Senator Harrison's gonna be doing the workers' comp section, so we will go over that. Thank you, very much for that. And now we're going to adjourn the committee for today. And then